good afternoon, or good evening, whichever we are. Um, since this is asynchronous, you are seeing this at your own place, at your own time. It's one of the new challenges of distance learning, but we will cope with this too, right? Right. So one thing that is important for law students who are 1Ls to remember is there are over 130,000 law students in this country that are studying essentially the same things that you're studying. So when you don't get what you're studying, there are 130,000 people doing the same thing. This lecture is on how to critically read cases. I know you all have been reading cases for a semester, but we're going to go through. So some of this will be repetition for some of you. Some of it will give you a new viewpoint. And some of it may just be old hat and you're putting in a half hour because that's what's required to get your degree. So preparing for class and critically reading your cases. I'm sure you all recognize the difference between pre-law and law school. The key to law school is understanding what the rules are and how to apply the rules to the fact situation in the case, and then to multiple fact situations, hypotheticals that switch the facts around, and how to do case synthesis, to tie the cases together so that you can see the evolution of the rule, the minority view, the majority view, the exceptions, the defenses, etc. Why do we read cases in law school? Well, you'll read hundreds and hundreds and hundreds and thousands of cases over your lifetime as a lawyer, and hundreds of them in law school. So since we're going to be required to do that, let's talk about the case method. I've looked at some of your CTE 3s, and it's interesting that you all differ on how long you should give to reading any single case. You should, in your second term, be a bit faster than in your first term because you're still a novice reader, but you are not as novice as the first time you opened that case book and thought, wow, what is this I'm looking at? The size of the reading assignment will vary. Your reading speed, not everybody reads at the same speed. Certainly, if you have reading challenges, I hope you will reach out to the wellness office and to Brett Bowers for an accommodation, but understand, if you will, that those accommodations are not generally given on the bar exam. A vocabulary, we've talked about that, and a level of focus. We talked about keeping a vocabulary list, and I know some of you are doing that. So, in the beginning, it's a challenge for law students to try to figure out what's going on logistically in any case. The language, the legal process may be familiar to judges and lawyers. Certainly to the judges that are writing the cases, they get the legal process, but that's part of what we're going to talk about here, in part because nobody ever really fills in those blanks, and there is an assumption, I think, that you know what some of those blanks are. Law students and lawyers read massive amounts of material, massive amounts. Your cases, your legal documents, legal opinions, briefs, memos, it's voluminous. And those who excel learn to read efficiently, which basically says you're moving through the information more quickly than your peers, you're gleaning more pertinent information from what you read. A successful lawyer and law student figures out what counts and they can find it quickly. Now, it's a little different in law school because we're expecting you to still brief your cases. But once you get that skill, reading cases becomes a more efficient process. So how does this evolve? In the real world, when you're advising clients, you'll begin to understand a little bit more by what we mean by rules plus facts equals analysis. Client comes into you and says, I've got this legal problem, and they tell you a story, a hypothetical. You will then go and try and figure out what rule or rules can help you win or not win a case. That is the analysis, and you will win or lose cases on whether a case or a rule applies to your client's situation, the facts, or whether, if the case isn't favorable, you will learn to distinguish it. And that is some of the point of the case synthesis work that you just did for class. Little things. Is it a verbal warning or a written warning? You can see that as an evolution, but you can also use it if you're arguing that second case to distinguish it from the first and say, well, that rule doesn't apply. You need to be actively involved in the text. Never read passively. What that means is you're not reading blindly for information like you'd read a phone book. You're actively engaged in a dialogue with the judge. Why is he doing this? Why is she doing this? Don't just check out and read things through with a yellow highlighter. That's not going to help you figure out what the point of the case is, what it stands for, what the rules are. Expert readers continually check to make sure their reading is making sense and that they can use fix-it strategies when their reading doesn't make sense. Keep a dictionary close by. Write your questions down so you can get them answered. In part, this is briefing in the margins. Strategies for becoming an expert legal reader. Well, one thing is watch your time. Given the pressure of constant reading in your workload, it is easy to see there's no room for falling behind. And that means that you need to stay current. It doesn't mean that what you do is you default to secondary sources instead of reading your cases. For one thing, you'll never learn to read cases that way. For another, you're not going to be a successful law student. Your GPA will suffer. If you do fall behind, you need to talk about a catch-up strategy. I'm available to talk about how to manage your time better, how to schedule your study. When you get into the real world, or if you've ever hired a lawyer, because lawyers tend to charge hourly, one of the biggest criticisms about lawyers is that they don't use time well, that they lack time management. You all have watches, alarms, phones. Put them on your table when you're studying and use them. Develop a hypothesis. What this means is, as you start reading through the case, try and figure out try to suss out the purpose of the case. Where is this going? What is the rule? Is it going to be a majority or minority? Try and keep your mind actively engaged with that. Rephrasing and reviewing. Expert legal readers rephrase or paraphrase difficult or long passages. So it is amazing how you can take cases and boil them down into just a few sentences. It takes a lot of work to do it, but you can do it. If you want, you can restate what you've just read. You can read out loud for kinesthetic readers, kinesthetic learners. Sometimes that helps. If you have a little kid who won't become bored when you're reading them a story that is actually a case, you'd be amazed how that might help you. And then taking notes or briefing it will keep you involved. So this is the 3-step process that we teach you about reading. 1, put the case in context. Which class are you in? 2, read the cases for an overview. 3, read the cases analytically. It's a 3-step process. It'll feel really lengthy and slow initially, especially when you have a mountain of reading to get through. But with practice, it gets faster. Reading critically from the beginning of law school or your first year in law school will pay off over time and when it's time to take your exams. Part of it is you're reading the cases to prepare for class, getting your case notes, and the idea is when you're studying for exams, you're going to be able to put it all together in a much shorter format to study from. Casebook reading, what not to do. I always like things that tell me what not to do before they tell me what to do. Why wouldn't you use highlighting alone? What is passive reading? Don't read passively. Make sure, like we just talked about, that you are an active reader. At least one of you really hates your casebook and contracts. So here's one thing that you should know. Your professor deliberately has looked at multiple casebooks and chosen the casebook that you are using. They choose it because they like the cases that are included, many of which are the same across casebooks. They like the editing because your casebooks are all based on edited cases and they're edited slightly differently. And every casebook provides a section on with some sort of notes. It's the text at the end usually, sometimes at the beginning of your reading, and problems. So your professor has chosen the book for a reason. They're aware of the table of contents and what cases are included. Put that in your head when you're reading and when you're preparing for exams. So, when you are organizing or synthesizing material, that's a step of learning in addition to just your reading. You're reviewing material, memorizing material, discussing cases with others, which if I've looked through, again, your CTE 3s, some of you just read the same case differently. So you need to think about what that means when you go into class and what you learn in class. Summarizing after class. Many of you picked up on the 10 minutes after class that is very helpful for you to use to review your notes, to fill in blanks, and to ask somebody what you missed, and to make sure that they're thorough, since that is, with the reading, going to be your outline, right? That's where your outline comes. Practicing exam writing strategies are other important study skills. Practice, practice, practice. You'll hear me say that over again. It is also, and you've heard this, I'm sure, important, particularly for you all with full-time jobs, to manage your reading, to manage your studies, so that you don't lose all of your personal time. Law school should take up a lot of your time, but not all of your time. The difference between an edited and unedited case. The cases that you see are edited. If you want to see what an unedited case looks like, excuse me, take the citation, and we're going to talk about what the citation is, and put it in Westlaw, and it will show you how it's in a legal reporter. And the case we're going to analyze, which is Fisher versus Carousel, is also at the Twin page, and is there in the form, I think, that's in the reporter. There are reporters for different jurisdictions: Northwest, Southwest, Southeast, Northeast. That's how they're grouped. Those are the books that you'll recognize from every time a lawyer is interviewed on TV. They're standing in front of them. I think they're published by Thomson West. And when I started my practice a billion years ago, they cost $5,000 to start, and then you paid for supplements. But because everything's online now, you can't even sell those suckers. So when I closed my law practice in 2006, it was very hard to find a home for them. At this point, their home is decorative, and you don't want to rent extra space for a law library anymore. So, strategies and tactics for critical reading. Knowing which court decided the case. When we talk about Fisher versus Carousel, we're going to talk some about why that's important. Learn the anatomy of the case. And find the legal issue on appeal. Because your cases, remember, are all appellate cases, right? It's rare for a lawyer in a law school to read a trial judge's opinion. In North Carolina, our trial judges in the state courts don't write opinions. The federal judges do. So, just so we can talk this through, I don't know if you know, the federal court system is the district court is the trial court. That's the original jurisdiction court, which goes to the Circuit Court of Appeals, which goes to the U.S. Supreme Court. In the states, you go from trial courts. In North Carolina, we have 2 levels of trial court. We have the Superior Court and District Court. I was a district court judge. District courts in North Carolina have jurisdiction over different things, original jurisdictions. All family law cases are in the district court case, district court jurisdiction. So they go then from the trial court level to, if you've got a question of law, to appeal to the intermediate court, which in North Carolina is the Court of Appeals, which then goes to the state's highest court, which in North Carolina is the Supreme Court. Anybody know what the trial court is called in the state of New York? So in the state of New York, the Supreme Court is the lower appellate court, and the Court of Appeals is their highest appellate court. Just a little tricky thing. I don't imagine any of you are going to be practicing in New York, but you just never know. So again, most states have a 3-tiered court system. This may or may not be something that you know. We have 12 circuits in the federal court system in the United States. And it's really interesting if you talk to people who are in the European system, they don't understand why we have different state laws and state courts and then different circuits, because they work with one court system. The English always get a little flipped out by this, which is so interesting to me. So notice that we have 12 circuits. Does it matter which circuit has decided a case? Well, if you were going to argue a medical marijuana case, is there a circuit you would rather be in than not be in? Yeah. If you could get it so that your plaintiff was, or your defendant was in the 9th Circuit, which is California and the West, that is probably going to serve your client better than the 5th Circuit, which is Texas, Louisiana, Mississippi. Note that Alaska, by the way, is grouped in with the 9th Circuit, and so is Guam and Hawaii. But interesting, Puerto Rico is with the 1st Circuit, and with the Virgin Islands are in the 3rd Circuit. And what you can't, so does that make a difference? Yeah. If you were going to argue for a 1-week waiting period and background check, sorry for my dogs, on gun purchases, somebody must be threatening as they're walking by the house, you'd rather be in Texas than in California. How about restrictions on prayer? Where do you think that would be best tried if what you were trying to do is uphold restrictions for high school, prayer and high school graduations? Different circuits have different kinds of judges, and that's been part of the controversy that's gone on with both court packing, which I know you've heard of, not just from FDR's time, but discussed more recently in the news, as well as remember that federal judges are appointed for life. In North Carolina, our judges are all elected. The district court judges are 4-year terms, and all of our other judges are 8-year terms. So, parts of a court opinion. This is the anatomy of the case. First thing you want to look at is the names of the parties. So, Fisher versus Carousel, first of all, was tried in the Supreme Court of Texas, or was heard. The case you're looking at is from the Supreme Court of Texas. So, that is in, let me see if I can go back, the 5th Circuit. And the names of the parties: Fisher is an individual, Carousel Motor Hotel Inc. et al. What does et al. mean? Et al. means and others. The first name party in a case is always the appellant, who is bringing the case to the appellate court from the lower court, and the respondent is the appellee or appellee, who's in court responding to the appeal. be careful. Sometimes the title doesn't accurately reflect appellant and appellee, so you need to read through the opinion, but that's the general rule. Citation. I talked to you before about if you want to look up a case. So this case is 424 Southwest 2nd. Southwest is, they group their reporters geographically. It's volume 424 in the second editions of Southwest. There was Southwest 1, now everybody's in a second edition. Nobody's gone to a third. And 627 is the page that the opinion starts on. This number in white is going to be the docket number, which is an internal docketing number for the courts. And you need to know the date of the opinion. We're going to talk about why in a second. The case of Fisher versus Carousel occurred in 1967. So, Texas in the 1960s. So summaries of opinions are written by the authors of the reporter, not the court deciding the case. Never, ever, ever cite them. Never, ever just read a summary and assume that you know what the case is about. You're not likely to find summaries in your casebook, which is part of why we're doing this, so that you see what a full legal opinion looks like. But sometimes you do see them. And this is what they look like. So in this case, the 61st District Court, that's a trial court. And Ben Wilson was the trial judge. And he granted the defendant's motion NOV. Anybody got an idea of what an NOV means? It is when a trial judge who sat with it in a jury trial grants a defendant's motion to set aside the jury's verdict. It went to the Waco Court of Appeals, which affirmed the trial judge, and then it went to the Supreme Court, where Greenhill wrote the opinion, and you see the holding there. Why do you care about judges? Well, as you get out and practice, you will learn a lot about who your judges are. It's very important to know the judge, know the judge, know the judge. Makes a difference in how you try your case and whether or not you're going to get how you. It may make a difference in how you structure a legal brief or an argument. Head notes. Never, ever, ever rely on head notes. I can't tell you the number of times the lawyers would come into my court and argue from the head notes. I read the case. I know that's not what it is. Again, this is, in this case, it's a key system. You see the little key right there? That is a number system that the West publisher uses so that you can connect doing research. They are not law. Never, ever, ever cite a case, a head note. I've read them and seen them where they're wrong. I've read them where they're misleading. Again, they are only the author's version. So often the name of a judge is irrelevant. So what we learned here was, and the name of the deciding judge, if you know something about the judge's persuasions politically, or the historical stature, or where they come from, all of that can influence a case. Cases by well-respected, widely known justices or judges, which you'll know these names. Cardozo, Thurgood Marshall. Those are often written in a compelling style, or because of where they are in the order of history, they carry a lot of weight. So, moving on to facts. Back. Dogs had to have dinner. What we know about Fisher versus Carousel is it's a suit for an assault and battery for damages, actual and exemplary. When you read it, the question is, can you figure out what exemplary damages are? and that may be a good way to find out whether you've read this or not, but exemplary damages are punitive damages. They're damages designed to punish. Plaintiff was a mathematician. We are in Texas in 1967. What happened in 1967? We had the riots, race riots in 1967. What happened in 1968? The killing of Martin Luther King Jr., the killing of Bobby Kennedy. Some of you may be old enough to remember those. I don't think a whole lot of you are, but that's why the date and the place are pertinent. The holding, it is, in this case, it's the court's decision. It is rare to find, not rare, it is not customary to find an appellate court that says we hold. It's very nice when you do, because you're looking for the holding of the case, but you don't always find the language we hold. In this case, that the forceful disposition of plaintiff's plate in an offensive manner was sufficient to constitute battery. Trial court erred, so now we know the Supreme Court of the state of Texas overruled the appellate court. Whoops, sorry. In this case, there is no concurrence or dissent. You will find cases particularly Supreme Court cases, where there are concurrences and dissents, and you must read them. Concurrence is when a judge agrees with the outcome but has a slightly different way of getting to that result. And dissents are judges who disagree with the result, and they're going to go out and state their reasons why. So, how do you dissect a court opinion? You find the legal issue on appeal. What are you looking for? Is there a problem based on factual histories, procedural issues, or substantive law issues, like a rule of law? Is it a mistake of fact? Is it a mistake of law? It is very difficult to overturn what you might view as a mistake of fact. More often than not, the appellate courts defer to trial courts, because the trial courts are the ones that see the witnesses and handle the evidence. So it is very difficult to overturn findings of fact. The law of the case is decided by the judge, or it's not decided by a jury. Remember, the jury applies the law to the facts. So the judge decides what the law is and what they're going to instruct the jury about. And an error of law can often be that a judge gave the wrong instruction or missed an instruction that he or she should have given. After reading a case, this is what you should know: the facts of the case, the arguments of both sides, the disposition, what happened. You should understand the reasoning of the judge, and if there are concurring or dissenting opinions, you need to do that too. So let's talk again for just a brief moment about Fisher versus Carousel. Why do we care that it is 1967 in the state of Texas? Well, facts tell you that you have a black plaintiff who was a mathematician, who was at a business meeting with his peers, and who was, the meeting was at the hotel, the Carousel Motor Hotel. There was the Brass Ring Club, which was the restaurant in the hotel, and the employee who actually snatched the plate was a guy named Robert Flynn. Why is Robert Flynn not even consideration as a respondent in this case? Yeah, he died. He died before the case was heard. So the case against him abates. If you're dead, they can't get damages from you. Generally, you can't substitute an estate for an individual. A whole different inquiry, if that's where we're going. We have a black professional in 1967, riots just before King is shot, very fraught times in the state of Texas, the South, tried to a jury. What did the jury do? Did the jury give damages to the defendant? Yes. A jury composed of 12 citizens gave damages to Mr. Fisher. What happened to Mr. Fisher? What was the issue? The issue was whether or not there'd been a battery. And the battery in this case was snatching that plate. He wasn't touched, but they viewed the plate as an extension of him. And that's why the jury found for the defendant. Now think about it. You got a jury of 12 people, Texas, 1967. That's a big deal. And then you have the trial judge. Now in Texas, all of your judges are elected. And I will tell you, as somebody who has sat as a judge, many judges are looking to see whether what they do will get them reelected or not. So what happened in this case? Well, this trial judge overruled the jury and said, no, not a battery, he gets nothing. So then they went to the Court of Appeals. Court of Appeals, still elected judges. They said, I think that trial judge is right. So what happens at the Supreme Court in the state of Texas in 1967, where you have to run, and I'm sure it was partisan in those days, because I know it's partisan now, with the designation of a D or an R by your name. This Supreme Court really was quite courageous for their time, and they went out on a limb for a black defendant. That's one of the reasons that context, who the judge is, can make a huge difference. You need to know so you can anticipate. Sometimes one of the decisions that you need to decide before you appeal a case is whether or not you're going to make what would be called bad law, an outcome that would be devastating in your field, that you really don't want the outcome, even though that individual may be somebody that you want to get a different result. So sometimes there are reasons to appeal and reasons not to appeal. The case is notable in the sense, in the context of its time. I know that most of the cases that you're reading now aren't in that context, but take a look at that and just note, some of you have talked, well, not actually, I'm thinking my other one else. You're not doing torts or criminal law yet, which have a tendency to be facts that relate more to where we feel we are today. Property, not sure that it's where that you think that that's particularly pertinent to your life. Contracts can be. I don't think the cases that you're reading are, but it's something that you may want to consider about what circuit it was in and when it was decided. It may have a difference when you're looking at what the majority rule is and what the minority rule is, and the evolution of how that came to be. So, going back to the very beginning, you're going to read hundreds and hundreds and hundreds of cases. And at the end, what you need to know at the end of each case is the facts, the arguments. These are, gee, what does this all sound like? It sounds like your essay answers, doesn't it? They give you the facts, and then you need to know the arguments, both sides. Is there minority, majority? Is there an exception, a defense? You need to know the disposition, so you need to know the rule. Understand the reasoning, why we have the rule. Can sometimes be public policy. Sometimes that's something you agree with. Sometimes it's something you don't agree with. reading the CTE3s, somebody wrote on their paper that they would have decided it differently than the majority did. And I think that that's a really challenging way to read cases and remember what they're about and why you would have found it differently. And then if there are concurring or dissenting opinions, you need to read those too. So that is, in sum, how to critically read law. Now that you're doing it in law school, you will be doing it for many, many, many years to come. And it's the way lawyers learn, and the way lawyers argue, and the way lawyers win, and the way lawyers lose. So with that, I look forward to seeing you all tomorrow night, because today is Monday as I record this, and we'll go from there. Looking forward to seeing your CTE2s. And for those of you who want to do CTE3, you will get extra credit for doing that assignment. Thank you very much for your time. Now I just need to figure out if I can sign out. I know there's a way to do this. Questions. If you have questions, contact me. Y'all know my email address.